Judges, please go ahead and introduce yourselves.
Hello, let me make sure I'm unmuted. I am Susan Arnett. I am a criminal defense lawyer in Honolulu, Hawaii, just retired from the Public Defender's Office, also teach at the University of Hawaii Law School, and very happy to be with you this morning, my time. I think it's afternoon, your time.
And my name's Andy Levy. I'm a trial lawyer in Baltimore, Maryland, and I also teach at both of Maryland's law schools, the University of Maryland and the University of Baltimore.
And good morning. My name is Anthony Miller. I am an alumni of the program. I competed in my senior year of high school at the district and state levels, almost made it to nationals. And then I've worked as a coordinator helping to coach students and teachers and organize the Nevada state competitions for the last 10 years since then. And this is my first year getting to judge at the national level. So I'm really excited to be here and hear what you guys have for us today. Thanks for your time.
Would you please introduce yourselves and your teacher?
Hi, I'm Will Griffith.
Hello, I'm Maggie Stevie.
I'm Liam Pergram.
Hello, I'm Ethan Talbot.
And I'm Juliana Russ, and collectively we represent Unit 4 from Highlands High School in the Commonwealth of Kentucky. Our teacher is Ms. Boyman-Hennies.
Thank you. I will read question 2 of Unit 4, which I am sure you are intimately familiar with, and then you can begin your presentation and the timing will begin at that time too. Members of Congress are not only legislators, but they are also inquisitorial and should meet frequently to inspect the conduct of the public officers. So said George Mason at the Philadelphia Convention. How effectively do you believe Congress has used its investigatory power? Explain the differences, if any, between Congress's power to investigate and the power of oversight. Which power, in your opinion, is more significant? How effectively do you believe Congress has used its oversight powers? You may begin.
Congress's investigatory powers grant the ability to inspect all things related to the development of public policy, including consistent review of federal agencies, principles, and other programs. Although the Constitution does not specifically mention investigatory or oversight processes, these powers can be interpreted under Article 1, Section 1 as a major component of American federalism, specifically within the legislative branch. As George Mason emphasized the need for inquisitorial legislators to fulfill this responsibility, it is important to note that he mainly...
Liam, your microphone got muted there somehow. You kind of like dropped out for a second and then your microphone muted.
Oh, I'm sorry.
That's okay. We'll give you a lot more extra time for you.
Right, if you can go back to George Mason. That's where we sort of lost it.
As George Mason emphasized the need for inquisitorial legislators to fulfill this responsibility, it is important to note that he mainly meant this in the context of holding public officials accountable.
Similar to Mason, James Madison anticipated this need for congressional inquiry in the Federalist No. 51 when he urged, "In framing a government which is to be administered by men over men, you must first enable the government to control the governed, and in the next place to oblige to control itself." This panel believes that Congress has utilized their investigatory powers sufficiently.
Arguably, one of the most well-known examples of congressional investigation is the Watergate scandal. Nixon's involvement with the break-in at the Watergate Hotel in 1973 prompted the creation of a Senate Select Committee. Further examination of the event led to the president's eventual resignation in order to avoid impeachment.
Additionally, the Privacy Act of 1974, Presidential Records Act of 1978, Ethics in Government Act of 1978, and the Foreign Intelligence Surveillance Act were all introduced to manage components of executive power that had previously gone unchecked. In an attempt to reform national intelligence operations, the Pike Committee, Rockefeller Committee, and Church Committee all influenced the gradual development of an accountable central intelligence agency.
However, there have also been congressional actions that exemplify an irresponsible or unconstitutional use of investigatory procedures. The Red Scare and rise of McCarthyism in the 1950s is a prime example of this. Republican Senator Joseph McCarthy led a number of hearings and investigations in an effort to expose suspected communist ties within the U.S. government. In tandem with McCarthy, the House Un-American Activities Committee was created to assist in the investigation of communist activity, often weaponizing their subpoena powers in the process.
In 1950, Congress went so far as to pass the McCarran Internal Security Act, which required all subservices in the U.S. to submit to government supervision. Ultimately, this aggressive approach resulted in innocent people being stripped of their civil liberties and persecuted unjustly. However, these standards have evolved since. This panel believes that in the present day, the investigatory powers of Congress is used very effectively.
Because investigatory and oversight powers of Congress are implied, these responsibilities have become somewhat blurred lines. Investigation can be used in order to help provide greater oversight, and correct use of oversight can result in more thorough investigation. However, there are important distinctions to make between the two. Investigatory powers are loosely defined as congressional ability to gather information, while oversight powers can be described as congressional ability to enforce government accountability. This panel believes that oversight is more significant than investigation because keeping government entities accountable is the first step to ensuring.
Without oversight, investigations and their findings cannot always be trusted. One example of a current use of oversight is in regards to the United States Postal Service. On February 24, 2021, the Congressional Oversight Committee held a bipartisan hearing to review plans to reform the USPS. The committee reviewed possible pieces of legislation that aim to boost federal financial aid for the service. This is an example of an oversight committee applying their powers to review the actions of an executive branch.
Even when considering the successful implications of Congress's oversight powers, partisanship at the federal level has limited the influence of this congressional role. Kentucky Senator Mitch McConnell's involvement with the second impeachment of former President Donald Trump is a clear example of this phenomenon.
Trump's impeachment trial was delayed until a new administration was in place. This delayed the oversight process as a whole, effectively limiting the success of the trial. Historic examples and this partisanship play a significant role in suppressing congressional oversight powers from reaching their full potential. Thank you, and we are now ready for your questions.
Thank you for the presentation. I'm interested in the distinction between what Congress has the power to do something about, and their use of their investigatory powers. So for example, when they held hearings on the use of steroids in baseball, or that called the tobacco companies before them in the 60s to talk about their knowledge of the danger of cigarettes, was that an appropriate use of their investigatory powers, even if there wasn't a direct tie to Congress's job? Or do you think there has to be a specific link to legislation that could be enacted as a result of an investigation?
I do believe that legislation should be tied to the investigations at hand, but I also believe that in the examples that you stated, like the steroid use and the health effects of cigarettes, I also believe that their investigations can determine whether or not legislation is necessary. For example, with the cigarettes example that you said, in order to gather all the information, in order to decide whether or not they want to enact legislation, they need to be well researched enough and well read enough to understand that issue to come to the right conclusion.
And can you point to the type of legislation that could be enacted once they've gathered the information?
Working with committees, well, not committees, but different branches of government that control, like, for example, like the CDC, even though the CDC isn't a branch of government, it's still, working closely with health departments and that type of thing to determine maybe age limits for buying tobacco, for example, in different states, maybe making that a federal limit or something along those lines.
To build off my colleague Julie's point, we see that the CDC is not in itself a branch of government, but more a governmental organization. And through this, we can see that they do have input within the government and with matters regarding health. For example, with tobacco, it could affect children if there isn't the right age limit. In steroid use, we don't know the full effects of health, the full effects it will have on a person's health.
In your speech, you said that there have been historically some usages of the investigatory powers that were irresponsible or even unconstitutional. You use the word unconstitutional, so I'd like to hear you defend that. How would you define when it is unconstitutional for Congress to use their investigatory powers? Irresponsible is up to an opinion, right? But unconstitutional seems to be like, okay, there's some guideline here that this is wrong, this shouldn't be allowed. Can you give me what you think those guidelines should be?
I believe the guidelines for if it is unconstitutional is if it steps over the personal rights of an individual. With the example I listed of the McCarran Security Act, which it violated the natural born rights of the American citizens. And I feel like once it violates the rights laid out in the amendment or in the Constitution, then it is declared unconstitutional.
Can you give me a little bit more concretion? Just educate me about that example, because I'm not as informed on it as you are.
I believe that example was from the 1950s, was with the internment of Japanese American citizens, just under the basis of during the stigma of Japan during post World War II.
Okay, so got it. I didn't fully hear what your example was. I missed that. So in that case, do you believe that the act of doing the investigation was unconstitutional, or the legislation that came out of it, or both?
I believe both of it was unconstitutional, as it violated the personal rights of those individuals, and in turn put them into internment camps, which is a gross violation of human rights.
I will have to say, I might take a different position than my colleague here, because I do believe that while obviously the internment camps, I believe, were unconstitutional based on a variety of factors, the investigation, in this case, I think it was, but I don't always think that the investigation has to be unconstitutional to go along with the legislation. Obviously, sometimes legislation doesn't match with the investigation. If the investigation is conducted in kind of an unconstitutional way, such as with the example we listed with McCarthyism, the Red Scare, the House Un-American Committee, Activities Committee, those are examples of which investigations themselves are unconstitutionally conducted, whether it be through violation of search and seizure procedures, that type of thing. But taking away other rights. But in this case, I do agree that I think that they can be separate.
When talking about these specific examples, I think it's important to note that, like, with that oversight and investigation process, specifically the investigation process, these decisions should be backed up by a significant amount of research, and hearing from our government officials should be educated in a way where they are hearing from the voices of minority voices and those that are significantly impacted by the problems that are addressed. So I think that that's just the most crucial process when determining if something is viable to be investigated.
So let me follow up a little bit on that, which is, that sounds more like a sort of a prescription for good government or best practices, or we would hope that they had done their homework before sort of having these hearings. But the position, but none of it seems tethered to the Constitution. So if the standard is they can't act unconstitutionally, how do we know? I mean, what do we ask the Supreme Court for an advisory opinion before the hearing can proceed?
Go ahead.
Sorry, Will. I think that the importance of having that accountability between the United States people and the federal government, as we can look back in 1960 with the televised hearings of the Senate Foreign Relations Committee with the quote-unquote Pentagon Papers, and that was solidifying public opinion to continue in the Vietnam War. So that sense of accountability and just universal knowledge that everyone is on the same page, and creating that sense of trust between the people and federal government is something that plays a role in that, I think, as well.
Will, you were gonna?
I was going to say that another way we can determine if it is unconstitutional is by turning to the Bill of Rights and the preamble of the Constitution, where it lays out that people have certain unalienable rights that it's time.
Well,
You can finish
your thought.
We can turn to the Constitution, where it lays out those certain unalienable rights that can't be infringed upon. And going back to my colleague Liam's point with the internment camps, that is infringing on certain rights laid out in the preamble and the Constitution that we can't infringe upon?
Thank you.
Okay, wonderful.
Thank you very much. First of all, you're all articulate, and I appreciate that you were informed as well as you were, as evidenced by your initial presentation. I think it was helpful for us, for you to, off the bat, indicate those that you felt were effective uses of investigatory powers and those examples that you thought were not. So I appreciated that. And I also appreciated that you had examples of the oversight and actually answered the question about which power is more significant. The McCarran example, you might want to give a little bit more detail to it, because while that was 1950, the actual internment was during World War II. And while McCarran justified the internment, it later was, there was other legislation in the 70s that took away that part of it. And of course, there was an apology later during, I believe, the Carter administration to the Japanese Americans who were interned as a result of Executive Order 9066. So something like that your listener may not be as informed about as you are, a little bit more detail can be helpful to put that in context. But I very much appreciated that you listened to the questions and your answers were directed at actually answering them instead of just talking about more information. Very nice job. Thank you.
So, yeah, no, I agree. It's a really interesting question. So if the standard is constitutionality and the Bill of Rights, so for example, the Fifth Amendment or the Sixth Amendment rights, Fourth Amendment search and seizure, I mean, those are all, for the most part, those are criminal procedure rights and have never been applied other than the right to invoke the Fifth Amendment in congressional testimony. There is not clear that the Sixth Amendment rights, the Fourth Amendment rights apply in the context. And I know that Susan will appreciate this, having been a criminal defense lawyer, that it always rubs me the wrong. I mean, it is presumptively prejudicial and improper to require a defendant in a criminal trial to assert the Fifth Amendment in front of the jury. It just would never happen. But it happens all the time in congressional hearings. And I find it grossly unfair, and it's just for theater's sake, but it isn't illegal, and it's never been held to be illegal. And so I do worry about this unconstitutionality standard. And the other example that occurred to me was, the law at the time of the internment was upheld in Korematsu. So if the contemporary understanding is that it is constitutional, and it's only with sort of the benefit of history that we reach a different conclusion, that also makes me wonder, sort of, is that really, how much of a protection is that really? So, so your presentation was really sort of the mark of a really good team, a really thoughtful presentation, in that it's sort of prompting me to think of things in a way that I hadn't before. And I wish we had like a lot more time to talk about this and follow this out. It's really not fair to try to address these things in 12 minutes, but that's obviously not your fault. And in terms of the constitutional conversation, I found yours just really, really interesting and well done.
Yeah, I mimic everything that was said by both Susan and Andrew. I think you guys did a really, really wonderful job here. I have both some really, really positive feedback and a little bit of constructive feedback for you guys. So I want to start by commending you for defending yourself when I pushed at you, because I really thought I was going to get you. You said these investigations are unconstitutional. And I thought to myself, well, Congress has the power to investigate pretty much anything they want. How can the investigation itself be unconstitutional? Sure, they could pass an unconstitutional law that should probably be struck down in the future. But I loved that you were able to get to, well, it wasn't just the law about interning Japanese Americans that was unconstitutional, but the actual acts that were taken during the investigation were a violation of individual rights. They, in the search and seizure and the way that they conducted the investigation, which was really an interesting point, because we are so concerned about that when we talk about law enforcement, right? We're very, very concerned about that. And no one really thinks about that when it comes to Congress, because they seem to have this overwhelmingly powerful subpoena power. And I thought that was really cool. Where my constructive feedback comes is I wish you would have gotten there quicker. And without as much digging and prompting from us. So I think that overall, like what I'm trying to say with my constructive feedback here is that we're talking about a lot of very complex, difficult legal issues here. And when you're talking about legal issues, you have to be very, very precise and very, very careful with your wording, right? If you use, in We the People, we tell students, make bold claims, give your strong opinions, but you have to back them up. And when you make a claim that is very bold and isn't a super popular one, or one we hear regularly that we kind of already know the logical chain of events to get us there, if we don't already know that, you need to lay that out for us. And it was a very, very powerful argument, but I wish that we wouldn't have had to spend so much time getting there, because we could have spent that time doing something else, right? So just understand that you have to think like a lawyer when you're talking about this stuff, because we are talking about law, and you have to be very, very precise with the way you word things. You have to be very precise with how you explain contentious issues like that. I think that you did a wonderful job, and that I don't disagree with your point, but I wish we would have gotten there quicker, right? The issue of Japanese internment, I think I actually disagree with Andrew on a little bit, and that's okay. That even though the case itself was, what Korematsu upheld the law in the first place, I think that there's two issues here. One, whether or not the popular opinion or the court at one time believes that something is constitutional, I think that we determined it wasn't eventually, and I think that was probably the right decision. But more importantly, just because that law was constitutional does not mean that the way we arrived at it was. Just because somebody is convicted of a crime, even if they were guilty, doesn't mean that the way that we obtained the evidence was constitutional, right? And that's why we have the exclusionary clause, and evidence gets thrown out of court all the time because of it. And I really like the nuance there. So I was really, really impressed with the depth of the analysis you guys gave, which is something that's very, very difficult, especially for high school seniors to do. I just would say going forward, try to be very, very careful with and precise with your wording. So great job, guys. You should be very proud of yourselves, and your teachers should be very
proud. Yeah, thank you very much. And the one other thing I say, we have pointed out to teams when we thought they had too much participation on each question, because it reduced the number of questions that we could ask. And I appreciate that you folks didn't do that. You spread it around effectively, I think, and it was, I think, tactically a good call on your part. Certainly, congratulations to your teacher, your parents, and most of all you, for everything you put into this, and it's clear to us that you did put quite a bit into it. So thank you. Good luck for the rest of the day.